Thank you all for your attention, and now I'll pass it over to Jonathan, who is our session chair.
Thank you, Shruti. So welcome, guys. Welcome, everyone, to this session on development in labor laws. We have three paper presenters, myself, Robert Hebdon, and Virgel Binghay. So I'll just start and share my screen now. Sorry about that. Okay. Let me just switch. Okay, so good morning. So my topic is about Spanish-American legal transfers, Australian parallels, and endogenous developments in Philippine labor law. By way of a background, I'm using an historical institutional case study method. And so the paper considers how labor law and regulation evolve in particular contexts and over time, and how this evolution impacts varieties of capitalism, labor market formation, and work creation. There's a lot of literature out there that delves into laws as dichotomous variables. Laporta et al. Talk about law transplanted through colonization, and thus legal origins, they argue, are key to understanding varieties of capitalism, such that civil law systems, which tend to favor allocations decided by the state, tend to correspond to coordinated market economies that involve strategic interaction among actors. The other side, of course, common law systems that support private market outcomes tend to correspond to liberal market economies driven by competitive markets. But there's another set of literature that delves into, treats laws as continuous variables. Kohler, for example, discusses civil law common law continuum of labor law systems, and looks at the German model as an ideal type, perhaps, if you will, of civil law labor law systems with its robust state help rules or features. State help here means individual labor laws that protect individual workers who are the weaker party in the employment relationship. That's at one polar end. At the other polar end, you have the US model as perhaps the ideal type of common law labor law systems with strong self-help features or rules. That is collective labor laws involving trade unions and employers as well in the process of collective bargaining, for example. This literature on laws as continuous variables also look into entangled legal histories and mixed legal systems. Entangled legal histories are complex, intertwined networks with no beginning and no end, and they tend to have difficulty in fixing their own points of departure. And mixed legal systems, well, these involve two or more legal traditions or parts thereof operating within a single system. Mixed systems and legal pluralism are closely associated with colonial rule. For example, Spain introduced civil law, but the US introduced common law in the Philippines, where indigenous people already had the customary law. And so it's not just about hybridity, really, and it might even be a trichotomy. And so I've developed this legal origins and varieties of capitalism continuum as a sort of a framework one polar end, you have civil law systems that might have coordinated market economies. At the other, common law systems with liberal market economies. And in between, you have this whole gamut of systems of endogenous origins, hybrids of civil law and common law, Asian market economies entailing networks and personal relationships, and trichotomies of indigenous law, imported law, and development law. And questions that could crop up in this connection would be, what approach has been used over time, and what might be the impact on work creation. And I have here the descriptive analysis of the key periods in the development of Philippine labor law. In the pre-Spanish era, there was a fragmentary a native system of customary laws, but the concept of a go-between or mediator was practiced in communities prior to the first arrival of the Spanish colonizers in 1521. The relations between capital and labor were mostly unregulated, even when the Spanish civil code was extended to the Philippine Islands in 1889. The scarcity of regulatory measures continued even after the 1898 Treaty of Paris, through which the Philippines was ceded to the United States by Spain, though in 1933, Act 4055 was introduced and provided for voluntary mediation, conciliation, and arbitration between employers and employees, as well as landlords and tenants. Similar to the Spanish Civil Code's philosophy of individualism in its property, obligations, and contracts rules, from which the concept of management prerogative was derived, Act 4055 was anchored to the laissez-faire approach of the US in the Philippine Islands. Upon the ratification in 1935 of the Philippine Commonwealth Constitution, social justice and compulsory arbitration became state policies in consonance with developments in the US during the New Deal era. And the following year, 1936, the Court of Industrial Relations was created through Commonwealth Act 103. The court had the authority to handle compulsory arbitration of all labor disputes, but precisely because it handled all labor disputes, the highly centralized system became unwieldy. So the court's dockets were clogged with cases as there was an overdependence on its jurisdiction. After the Philippines gained formal independence from the US in 1946 as a republic, the Industrial Peace Act, Republic Act 875 of 1953, was passed, and the major shift in the method of handling labor disputes occurred from centralized compulsory arbitration by a court to a decentralized system involving the rights to self-organization and collective bargaining within enterprises that followed the model under the U.S. Wagner Act of 1935. The court's role was diminished under the Industrial Peace Act, but not removed. However, the stage of collective bargaining under the Industrial Peace Act also had limitations, such as the lack of effective implementation or enforcement of collective bargaining agreements, and the cumbersome nature of the quasi-judicial machinery for the resolution of representation and unfair labor practice cases. So the Philippine Labor Code, Presidential Decree 442, became effective in 1974 during the martial law period. State regulation of the relations between capital and labor, workers and employers, and the assurance of workers' rights to self-organization and collective bargaining, among others, are the declared policy under the current code, which abolished the Court of Industrial Relations, formalized the National Labor Relations Commission, and transferred the pending labor cases to the latter. Importantly, the exported labor policy was also institutionalized under the Labor Code. The ratification of the 1987 Constitution set in motion the reconstruction of democratic institutions in the country during the post-martial law years. So the present Constitution expresses a preference for voluntary modes in settling labor disputes, including conciliation. As a consequence, several laws amending the Labor Code have been enacted in order to bolster, self-organization, collective bargaining, and the voluntary modes of settling labor disputes. In this vein, the Secretary of Labor and Employment issued a key regulatory measure on mandatory conciliation and mediation in 2010 called the single entry approach. And what seemed like a follow through to the single entry approach, Republic Act 10,396 was passed by Congress in 2013 to strengthen mandatory conciliation and mediation for all labor and employment issues. Thus the wheel seems to have come full circle back to the go-between or mediator of pre-Hispanic times, conciliation, mediation through single entry approach, and Republic Act 10,396 has resurfaced or reemerged as an innovative compulsory state help dispute management mechanism for unorganized establishments and individual labor disputes, other than the extant and more dominant state help dispute resolution mode of compulsory arbitration by the National Labor Relations Commission. As well, several legislative bills have been submitted proposing the Magna Carta of workers in the informal economy from the 14th up to the present 17th Congress of the Philippines. So you have here some of the Spanish-American legal transfers I was talking about, Spanish management prerogatives, American freedom of association and collective bargaining, and some forms of legal endemism, which by this I mean idiosyncratic, endogenous, and enduring persistent features of the legal system. For example, forms of enacted legal endemism I mentioned, the exported labor policy in the 1974 Labor Code, and state help conciliation mediation under Republic Act 10,396, and then forms of unenacted legal endemism, proposed bills regarding the Magna Carta of workers in the informal economy. And here I have some explanatory substantive themes. Of course, informality is huge in the Philippines, and that is why we have several versions of the proposed Magna Carta of workers in the informal economy. This suggests there is a strong demand for development law of this sort. And that's because the labor code and its current language and phraseology tends to, or is unable to encompass, workers in the informal economy. The second theme, Spanish-American antecedents, of course, is clear from the discussion that I gave. And the third, well, from 1950s through to the 1960s, the Philippines adopted an inward-looking, capital-intensive import substitution industrialization approach, which was the context for the shift from arbitral to bargaining mode. And this brings me to the next slide here, which shows us some parallelisms between the Philippines and Australia in terms of deregulation and decentralization of the industrial relations and employment relations systems in these two countries. The Philippines shifted, for example, from compulsory arbitration to collective bargaining in 1953 during ISI, and some 40 years later, Australia shifted from compulsory arbitration to collective bargaining in 1993 within its transition from protectionist to open economy. And then in terms of the body involved, well, the Philippines shifted from the Court of Industrial Relations to the National Labor Relations Commission in 1974 within an export-oriented industrialization approach. And Australia made a similar shift from the Commonwealth Court of Conciliation Arbitration to the Commonwealth Conciliation Arbitration Commission in 1956, and it has been a commission as well throughout over time with different names. And I mentioned the export-oriented industrialization approach. Well, yes, the Philippines from the 1970s embarked on an outward-looking, labor-intensive, export-oriented industrialization strategy, together with the exported labor policy I mentioned earlier, which was institutionalized under the 1974 Labor Code. And this pretty much contributed to the growth of the service economy and underemployment and informality, which you can readily see from this figure that shows the labor market, basically labor market structure in the Philippines. The blue line indicates agriculture sector, the yellow services orange industry, and the gray one, manufacturing. You can see the upward movement from 1970s up to the year 2000 of service sector, and the downward movement of agriculture, but manufacturing and industry has remained quite stagnant. In 2016, for example, the services sector comprised more than half of the total employed, about 55%. From the 1970s, when the labor code was enacted, to the present, employment in services has grown by almost 27%. Employment in agriculture has decreased by nearly the same proportion, while that in industry, manufacturing, well, they hardly moved, as I said earlier. And the labor code has contributed to the growth of employment in the services sector, where low productivity and low paying jobs are abundant, and quality of employment is doubtful. And underemployment rate has reached 19.2% in later years. And the extent to which services has grown over time suggests that the informal sector has expanded as well. And International Labor Organization estimated in 2012 that informal workers constituted about 70% of non-agricultural employment. And this represents pretty much the labor law coverage gap represented in this next slide. You can see here the labor law coverage gap, which is 70% of non-agricultural employment. These are persons in informal employment. So going back to the remaining substantive themes here, well, hybridity is pretty much explained by the Spanish and American antecedents mentioned earlier, but this hybridity informs the expansionary logic of management prerogatives and unemployment, because employers are able to assert property rights and managerial prerogatives based on civil law when deciding to reduce labor cost, notwithstanding the existing labor relations rules founded on common law that aim to protect workers. This paradox has translated into system incoherence or inconsistency in which trade union density and collective bargaining agreement coverage are very low, and compulsory arbitration incidence is very, very high, actually. And so, for example, from 2008 to 2014, gross domestic product growth averaged 5.4%, but it was a jobless growth as unemployment rate reached above 7% in the same period. And overall, there's been a trend towards individualization and decollectivization of employment and industrial relations. So in conclusion, the neat characterizations that some of the comparative literature on legal origins or varieties of capitalism might suggest are not necessarily reflected in Philippine labor law. The discourse here indicates entangled legal histories of Spanish-American legal transfers, including the antecedents and Philippine labor law. Though the latter, Philippine labor law, exhibits endogeneity and heterogeneity. For example, there's a trichotomy of indigenous law, imported law, and development law extant in the Philippine labor law system. Elements of Asian, coordinated, liberal market economies are present or traceable as well. Asian, well, the informal economy, coordinated, the ISI strategy, and liberal market, EOI strategy. And so the Philippine system's legal and economic pluralism and unemployment, underemployment situation might have a relationship, and the incompleteness of the labor code and absence of regulatory framework for informal work, because the Magna Carta has not yet passed as of the moment, could be among the many complex factors at play. Thank you. So let me just unshare my screen. Oops. I'll stop share, sorry. Okay, so our next presenter is Robert.
Mute.
Yep, you can start now if you wish. You can start.
First of all, thanks, Jonathan. I'm going to try to do a share here. Well, welcome everybody. especially in Montreal, it's early in the morning on Saturday, so hats off to everyone that has shown up for this. Everybody see the screen okay? Well, you'll let me know if you can. I'm going to talk about two issues, and I'll try to, because it's an international audience, I'll try to give some more background than on the slides about the uniqueness of the Canadian system of courts and legal decisions and so on, and particularly our Constitution. I'm going to talk about two issues as it relates to the Constitution. One is the ending of strikes through back-to-work legislation, and the second is wage control legislation in a number of provinces. I'm looking at particularly Nova Scotia and Manitoba, but Ontario is also can be added into this list of provinces that have instituted wage controls, basically during a period of fairly normal. This is before the COVID crisis. There was a normal period, I would describe it, in terms of government financing and the economy in general. Both of these topics, that is back-to-work legislation and wage controls, have involved constitutional challenges by labor in Canada. And there are important industrial relations questions to be answered as part of the challenge process. My role in this challenge process was as an expert witness in some of the cases, as you will soon discover. First of all, I should identify too that I'm not a lawyer or a legal scholar. If you're watching this presentation hoping to gather some scholarly material about these cases, you're probably going to be disappointed. This is more of just a report. It's not actually, I'm not planning on publishing anything on this, although there is a possibility. I think these industrial relations questions that arise out of these cases are interesting and probably worthy of publication somewhere, so I might work on that in the near future. So my role then is strictly to deal with the industrial relations aspects of these cases, and that's what I want to talk about today. A little bit of context. 1982, Canada got its own constitution, and included in that was the Charter of Rights and Freedoms. One of those rights and freedoms was the freedom of association, Section 2D, which is going to be the subject matter of the cases I have before me. Two decisions gave rise to these cases that I'm going to talk about. I think largely two cases. That's my assertion, at least. In 2007, the BC Health case said that within the freedom of association concept within our Constitution is included collective bargaining. So collective bargaining became part of freedom of association. That is, if freedom of association includes the idea that workers can collectively bargain with their employer. Then about 8 years later, the Saskatchewan Federation of Labor case said that also included in freedom of association is the right to strike. So this gave rise then to, after 2015, some challenges that relate to the question of wage controls, that is interference in the collective bargaining process, and also back to work legislation. Ending strikes, because strikes were protected after that point. But there's some difficult questions that arise. Well, it's true that strikes and collective bargaining are both protected under freedom of association. The question is, what does that mean? And what are the industrial relations aspects of that? So one of the questions, industrial relations questions, is particularly with reference to the back to work law and ending strikes, is what is an appropriate strike substitute? And secondly, under the wage control law, one of the questions is, well, it's an obvious one, I guess. What is collective bargaining? And I think more importantly, what is not collective bargaining? When does collective bargaining cease to be collective bargaining, or meaningful collective bargaining as a term used by the courts. And I think these are uniquely non-legal questions. These are more questions that we look at in industrial relations, hence my involvement in these cases. On the back to work law, the major decision on this one was in 2000. Actually, it was a back to work law in 2011 that took 5 years to decide in the courts, finally decided by an Ontario Superior Court in 2016. This was a lockout, strike lockout, it was a little bit of both, by the postal workers in 2011. And the workers were forced back to work, and the union challenged it, and I was part of that challenge process. Out of that Ontario Superior Court decision, they found in favor of the union, and they said that governments must provide an adequate strike substitute. That adequate strike substitute was identified as a fair arbitration process. That is, arbitration, third-party binding arbitration must be substituted for the strike. There must be a neutral chair involved in that. In other words, there must be some kind of process for selecting a chair that's neutral of the arbitration process. And this is an important aspect too. The idea here is that all of the issues in dispute must be settled by the arbitration board. So government can't simply impose their own solution. And what happened in the postal worker case is that government imposed a wage package on the union lower than what was on the bargaining table. I mean, I described in my affidavit that this was in fact punitive in nature. They were punishing the workers for going out on strike, or actually in this case, taking a lockout. So the court decided that what the government had done in the case of the back to work law in 2011 was wrong, and that in fact there must be a fair process for effectively continuing the collective bargaining process until it's resolved by an arbitrator. So this gave rise to a case in Nova Scotia that I'm involved with. February 2017, the government passed a law ending, again, another work to rule by teachers. You know, and I have to say something here too. I'm not dealing with the question of whether it was justified or not, whether the law was justified or necessary. I'm dealing only with the question of was the process itself adequate? The other question is a different question under our legal process. So looking at the process, this is what the government did in Nova Scotia. The law imposed a contract, and you should know that the teachers had rejected 3 previous settlements. That is, the members, the teachers, had rejected 3 contracts that were recommended by the bargaining team 3 times. I think it's some kind of a record. And actually, one of the industrial relations questions that gives rise from this is, why are contracts rejected? What is it about the process? And I tried to probe that a little bit in this affidavit. And I think it's actually a subject that is worthy of further investigation, because I didn't find any literature on the subject, or virtually almost nothing. So by imposing a contract, the government did not complete the collective bargaining process through arbitration, obviously. This was not an adequate substitute. And this did not follow the decision in 2016 of the Ontario court at all. In fact, it virtually ignored it. One wonders whether the advisors to the government actually read these decisions. But this is what I call a slam dunk. This is going to be a win for the union, I'm almost certain, if they follow it all. The courts in Nova Scotia follow it all, the Ontario decision. And I'm pretty sure it'll stand up before the Supreme Court if it gets there. But it's bogged down in the courts. The government is challenging admissibility of evidence and so on. It's going on. Anyway, I have a report from the lawyers that we don't have a decision pending on this one. It's going to be a while. But I think it's definitely going to be a win when it comes. Public sector restraint, another whole topic other than my involvement started with this back to work legislation, and it's evolved into this Nova Scotia and Manitoba restraint programs. And both Nova Scotia, actually Nova Scotia did this first, and Manitoba more or less rubber stamped the Nova Scotia legislation. There are some minor differences. It's 4 years of wage controls, 0% and 0% in the first 2 years, 0.75% in the third year, and 1% in the fourth year. And that's generally the pattern. It's a little different in Nova Scotia. They added a 0.5% at the end of the fourth year. So they claim that we're bringing in wage controls, but meaningful collective bargaining is still allowed on all other issues. That is, you can still bargain over non-monetary issues, and such things as job security are still on the table, and you can still negotiate them. The fact that wages are settled doesn't preclude bargaining on the others. So this Supreme Court of Canada phrase, meaningful collective bargaining, is still possible, and they put that phrase right in the legislation. But I asked the question, and this is what we discussed with the law firms, meaningful collective bargaining. Is it really possible or likely with much of the monetary value of a settlement already determined by the government? I have to say I have about 24 years as a practitioner involved in collective bargaining before I became an academic, another 24 years. I'm sort of giving away my age here. But my practitioner experience tells me that once wages are settled, it's virtually impossible to negotiate anything else. Especially if the top priority of the workers is wages and monetary issues, which it is most of the time. So this is one of the key questions that I was asked by the labor law firms. And I argue in affidavits for the Manitoba and Nova Scotia Federations of Labor that meaningful collective bargaining is almost impossible under these laws. That's a very carefully chosen phrase because, as you can see, I'm not saying it's impossible. In Manitoba's case, there were over 300 contracts up for negotiation. And I'm not going to predict that in 300 contract negotiations, there won't be settlements and there won't be issues that are non-monetary in nature as priorities and so on. So I never really said that it's going to preclude collective bargaining on non-monetary issues in all situations, but I'm just saying in the vast majority of them, there won't be meaningful collective bargaining taking place. I tried not to overstate the case. So what is collective bargaining? It's obviously the core function of unions, and employees join unions for a lot of reasons actually, but one of the main ones is to improve their wages and working conditions. And collective bargaining is clearly the primary vehicle of this change process. The bill numbers are not important, they're laws, and Bill 148 is the law bill number in Nova Scotia, and Bill 28, the parallel bill in Manitoba, is Bill 28. They're called the Public Sector in one case and Public Services Sustainability Act, but in both provinces it's the PSSA. So by removing key monetary issues from the scope of bargaining, union members can no longer voice their true preferences. Or if they do, the union cannot satisfy their demands. If wages are predetermined, unions cannot trade off for job security or other issues, thus a loss of bargaining power. And there are lots of cases put in evidence, some by the employer, some by the government side, of the unions agreeing to major concessions in bargaining in turn for job security. Well, imagine how that would happen under these laws. Management already has the wage settlement that they want. They got 0.75 and 1% they got a 4-year deal. It's a dream deal for them. It's substantially less than what the pattern is elsewhere in the public sector and private sector. So you go to the bargaining table with wages already settled and you say, okay, I want a job security clause. We've made these major concessions and I would like a job security clause. What pressure is on the employer to grant that job security clause? Well, the answer is zero pressure. They don't have to grant job security clause, and unions are not achieving them in Manitoba, as the cases showed. So I think of this as a loss of bargaining power, significant loss of bargaining power on the part of the union. What is the implication of these cases? I don't think I'm exaggerating this. Again, this is a non-crisis period. There's no international financial crisis. It's not like 2008 and all the other cases that were associated, Supreme Court cases that flowed from 2008. This was, at least prior to the virus, a fairly normal bargaining period. Governments had deficits, but they weren't in crisis. So the ability of governments to bring in wage controls in what I would describe as kind of a normal bargaining year was at risk here. And if governments were allowed to do this, I think it signaled the end of public sector collective bargaining in Canada. And I tried not to exaggerate that, but that's my position. So when I started preparing this presentation, I didn't have any decisions to give you, except a lot of court proceedings stuck in the courts. But luckily, on June 11th, 2 weeks ago, we got a decision out of the Manitoba Court of Queen's Bench by Judge J. McKelvey. It's 230 pages. I recommend that you see it. Am I being notified of my time? No. So I'm going to give you a few excerpts from that decision. The first, well, let me just preface it by saying the union won. This was a great victory for the Manitoba Federation of Labor, and hats off to the law firm of Myers out of Winnipeg that presented this case. I worked particularly closely with Shannon Carson, who I have to credit for her great work on this case. It was outstanding. This, I took this from the 226 or 230 pages. I took this quote. Dr. DiMatteo was actually the expert witness for the government. And he was the economic finance expert. And he acknowledged in his testimony, this is a quote then from the decision, said during the course of cross-examination, Dr. DiMatteo acknowledged that the Manitoba economy recovered quickly after the 2008-9 recession. It was described as robust compared to others and not in crisis in 2016 or thereafter, which is when the law was introduced. It was said to be in the middle of the pack. So this is the government's expert admitting that they were not in any sort of financial crisis in the wake of the introduction of Bill 28 and the Public Services Restraint Act. I'm sorry, but I couldn't resist putting this in, and I apologize for this because it's a little bit self-serving, but this is what she said on my notion that you can't bargain when wages are already predetermined. This is paragraph 333. I accept Dr. Hebdon's conclusion that, quote, with monetary issues already predetermined, meaningful bargaining is unworkable and almost impossible. And that was a quote from my report, September 17th, 2019. And then she added, this constitutes substantial interference with Section 2D rights. Section 2D is the freedom of association protection.
I guess.
And then, yes.
Actually, we've overshot a bit, but you can probably wind down now.
Yeah, I can. I think I'm on my last slide, and I'm sorry I took it long.
That's okay. That's okay.
And then Section 426. Or paragraph 426, she concludes, I've concluded that the PSSA operates as a draconian measure that has inhibited and dramatically reduced the union's bargaining power and violates 2D associational rights. There is no meaningful bargaining leverage afforded in the current situation. Will it be appealed? Good question. I can leave that for the questions after. So thank you.
Okay, thank you, Robert, for that very interesting presentation. So now we go to our third presenter, Professor Virgel Binghay from the University of the Philippines. And if you're okay.
At saka dapat makita ako. Dito yung ano yung
Naka-share ko yung stop ko muna share.
Sige, share. Hi, good evening. Can you hear me?
Yes, we can, Dong.
Hello.
Yes, we can.
Yes, we can. Dong, yes, we can.
It's nice to see you, Dr. Saleh and the rest of the guys. Arlene, how are you? I hope I would have wanted to see both of you there in Canada. You are in Australia now, right? Okay. So the topic of my presentation, which is going to be very brief, is seeing labor from the middle, HR practitioners on the status and improvement of labor laws compliance in the Philippines. Just a minute. The pointer. Okay. So just a little explanation. When I say HR here, one of the functions basically is to ensure that they would champion as they would act as employee champion, bridging the gap between top management and the workers. That's why I use the word middle. No? So it's a middle, supposedly is a link, linking top management, the owners, and that of the workers. And in this case, it's relative to the labor law compliance. Okay, I am Binghay. I am from the Philippines, and it's past 9 o'clock in the evening, almost 10 o'clock. Okay. Pakiano muna. So this is the Philippines, the map of the Philippines. There are around 11 million Filipinos as of the latest count. And the Philippines is a member of the International Labor Organization. It has been part of the ILO since 1948, and still it is very active since then. The Philippines has ratified a total of 38 ILO conventions, including all fundamental conventions that covered the 1998 Declaration on the Fundamental Principle and Rights of Work and its follow-up of and two governance or priority conventions on tripartite consultation and employment policy. The latest ratification is labor relations with respect to public service, and that is Convention 1978, number 151, which the Philippines ratified last October 10 of 2017. The Philippines, by the way, is the first country in Asia and the Pacific to have ratified this particular convention. However, the Philippines has yet to ratify ILO Convention 81, and that pertains to labor inspection, the industry, and labor convention number 129. That's again labor inspection in the agricultural areas, agricultural concerns. Instead, despite that, the Philippines, the country, observes compliance within the general context of general labor standards of the ILO, and likewise on the occupational safety and health standards, the OSH, as monitored by the labor laws compliance system of the Philippines. Convention number 81 sets out basic international standards, while Convention number 129 acts as supplemental instrument considering the unique characteristics of the agriculture sector. Labor inspections are an essential tool in ensuring that labor standards in ILO conventions and their corresponding national laws are maintained. Now let's try to look at some statistics, and this is coming from the government, the Philippine Statistical Authority, in 2016 release, the latest. It indicates here the distribution of establishments with total employees of 20 and over. 20 and over. So this does not include the micro enterprises, and they are distributed by regions. So as you will see here, the most of the companies, most of the establishments are based at the national capital region where Metro Manila is located. And this is closely followed by the Calabar zone, where you will have export processing zones located in Batangas, Cavite, Calamba, Laguna, etc. Then Central Luzon, and down the line. So it is not equitably distributed. As you will see, as you move down here, this is where we have more problems in terms of we have more conflicts, we have more insurgency problems here. And so I think we could correlate already here somehow employment, because these companies, the establishments obviously generate employment and conflicts, no? The conflicts. These are conflictual areas. All in all, there are, as of 2016, of course, this must have increased, but because of the pandemic, I believe it must have gone down again because many companies have closed down. The Philippines had a total of 35,835 establishments. Now, let's try to look at it. Now, in that figure, this area here, this accounts for the micro enterprises, and that's 88.95%. And the small enterprises account for 10.58%. The medium accounts for 0.49%. So if you look at that, and if you have look at here the distribution. By the way, the data here is this is coming from PSA also, Philippine Statistical Authority, but mostly coming from the Department of Trade and Industry. The total number of establishments is was rather this 1,300 3,111. So if you notice, this is a discrepancy, but the biggest chunk basically is attributed to the micro, small, and medium enterprises. Now, why am I giving you that backdrop? It is because the thing that I'd like to show you now is, okay, if the number of companies, the number of establishments are increasing from this period to that period. 2015, it has decreased, but somehow it is more or less the same. 2004, 2015, 2016, 2017. Now let's try to look at how many of these establishments have been inspected by the labor compliance officers. So you would see that in 2004 is around 68,000 versus 946 or 47,000. This one, 44,000 vis-a-vis that one, and that one, and that one. So if we try to figure it out, you would see here with are the company, the number of establishments and the number of companies that have been inspected. In short, what can we say? Fewer companies have been inspected. And so the number of establishments violating general labor standards are here. basically in terms of percentage, it's almost the same. And those that are violating occupational health, safety and health standards are also more or less, well, actually is more or less the same here. It has fluctuated here, but more or less the same here. So what can we infer from here? So many companies have not been inspected. Now, in the news, if you look at if you read the news, we have so many cases of violations, like companies that have been burned down, employees that have been charged because of the burning down of those company premises. We have ships that have collided with other ships in the ocean, resulting in deaths of not only the employees of the ship in those ships, but also the customers of those ships. We have rampant what so-called labor-only contracting arrangement, mode of arrangement, of which we have we connotate some people as perpetual contractual for so many years. Their right to security of tenure is never afforded to them. Now, I tried to look at again the data from the Department of Labor and Employment as to what are these typical standards that have been the object of violation. As you see here, the gray, these are the gray, no? We see improvements. And in this color, the brown, you would see the pattern slightly increasing. So I guess the biggest change, although this is still in 2016, I believe we don't have yet the new administration here. This is still based on the past administration. The frequency of payment issues has gone down significantly. The underpayment of the cost of living allowance has gone down. The non-presentation of records relative to employment of the employees has also gone down. And this one talks about child workers. It becomes zero. But again, in the news, we always hear the prevalence of child laborers as sort of indivisible, invisible part of the workforce. Now, what about in terms of health and safety? So I have highlighted in color here, including this one here, those that are still in the 2-digit level, like the inadequacy of first aider, the non-keeping of medical records, okay, and no safety committee, no minutes of safety committee meetings, non-submission of accident reports, and non-submission of annual medical reports. Again, these data are anchored on a very limited number of establishments that have been inspected by the Department of Labor and Employment. Now, let's try to look at the labor inspectorate in the Philippines. The Philippines has a labor laws compliance system, and the procedures for uniform implementation. The former Secretary of Labor came up with a manual on this, and it is available in the internet for the parties, the labor and management representatives to read. It was developed by the Bureau of Working Conditions to guide the Department of Labor and Employment, regional directors, and labor laws compliance officers. Earlier in my presentation, I showed you the establishments the number of establishments based on on a regional basis. So we also have what we call regional directors of labor and employment, and under them are what we call labor laws compliance officers. Some of them are at the provincial level, and some of them are at the city level. Now, the Labor Inspectorate in the Philippines, it is aimed at providing a standardized and synchronized implementation of procedures, such as joint assessments between employer representative and worker representative, or union representative for that matter, or there could be some compliance visits, especially if there are reportage on violations that would land into the office of the Department of Labor. And the other one has something to do with occupational safety, health, and standards investigations. So I won't discuss in detail the differences of the three, but there are concrete steps that would have to be followed, and each of these would have their respective purposes. The former administration lamented that this the policing approach to labor compliance is not good. So from policing approach, they come up with a non-policing approach. For the government, the police approach has alienated both employers and workers from the process of ensuring labor laws compliance and cultivated a level of distrust at the plant level with enforcement officers. So this small research was conducted to determine how do HR practitioners find the state of labor laws compliance in the Philippines. Second question is that what are their views to further strengthen compliance to protect the interests of both labor and capital, employers and the workers. The method is qualitative and using focus group discussion, and data were presented according to themes and patterns. And I attempted to triangulate the findings that I have gotten through this particular small research with the small research that I also did, which I presented in Australia last February. And it has got to do with the viewpoint of the union as to the state of labor compliance in the Philippines. Somehow I have tried in the presentation later, I will show to you some convergence and also divergence of viewpoints. In the paper, because this is already a completed one, we used pseudonyms of the participants. By the way, the participants are all HR people, and among several who were invited, I think a total of 20, only 6 came during the discussion that was held at the University of the Philippines in my college. As a result, the findings, by the way, this is qualitative. The findings could not be generalized considering the qualitative nature and the number of FGD participants. But somehow, it would probably provide us some idea about what are their thoughts about the state of labor compliance in the Philippines and the issues and suggestions for improvement. So let me go to key findings. Key finding number 1.
You have 1 minute,
there are
Don?
several. Yes, sir.
You have 1 minute.
Okay. There are several changes recently on the LLCS. There are so many department orders that they have to master. Participants were all aware of the LLCS. This is so I gave them questions about the LCS and to see if they know it, and it seems that they are fully aware. All of them were able to participate in labor monitoring in one form or another, so they have experience relative to it, and they have had unique experiences with labor inspection, different experiences. Some are positive, some are negatives. And with regards to positive and negative, some would say that there are cases where it is reliable, some cases not reliable. In terms of assurance, some is okay, some is not. In terms of the way the compliance officers are dealing with them, some are empathetic, some are not. And in terms of responsiveness, and I think this is something that they drumbeat, some felt not so responsive, but also some would say responsive. In other words, there are some hits and misses. The majority believe that labor-related standards were easy to comply if the owners of senior management want to. I think I would like to highlight this because this is very nice thing to say. So when nice things to note. When I probe, why did you say that? They felt that they feel for the people. They want to improve the lot of the people, except that whenever there are huge cost implications and it will affect the product profitability of the company, the number one that will object to their proposition to abide with the labor standards would be the employer. In other words, this goes to show to the very first statement that I told you earlier that these guys, the HR, is really the people in the middle. So they qualify it. They say if the owners or senior management would want to, labor standards compliance is easy. Most of the challenges are pertaining to it. So this is difficult. This is challenging whenever there are infrastructure issues or improvement that would entail a huge amount of money, and it would affect the company coffers. Out of all the participants, only one said that she had not undergone training on LCS. However, she resorted to informal learning approaches or modalities so that she will be abreast with what is going on. As I was saying earlier, they noted that there were so many changes that are going on. The rest have attended in-house training and public-run training like those conducted by DOLE. My school, the University of the Philippines, also conduct similar training programs on this. Some participate on their own volition, and their satisfaction with instructions, however, is dependent on who is conducting the learning sessions. Some were happy, some were not about it. Everyone claimed that there exist several modalities of management monitoring network on LCC. In other words, if you have labor monitoring system, they also have management monitoring network relative to labor compliance. They have employer associations, and they also have some group chat or social media discussions. Although some had mixed feelings about it, most of the participants felt like inspectorate is getting better. So this is good news somehow, especially when it comes to enforcement. They find it more strict during the administration, the current administration is more strict, and they see more labor compliance officers visiting them, and they said that it was not like the previous years. And also they have now technologies to capture real-time documentation of the data. They do recognize that increasing compliance with labor laws is always a collaborative effort between government and the company and management. So the role they assign to the government seems to be to adjust the systems to make them more efficient and transparent. I would explain that a little bit and very fast later on. In short, they're having some suggestions. The government should also do some fine tuning about the system for it to be more adaptive to the time. And they feel that the role of the company really is to comply. Unanimously, they felt that the current structures present are not favorable to small enterprises, to micro, small, and medium enterprises because of the financial cost, as well as the cumbersome bureaucratic requirements that need to be met. So if you have to look at the commodity chain, especially, these are the very, very small enterprises who probably would not even have any margin at all if you will have to have the same set of standards that you have for large organizations. Conclusion, how do HR practitioners find the state of labor laws compliance in the Philippines? Well, it's mixed. There are hits and misses. There are positives and there are negatives. One thing is sure, it's more strict now compared to that of before. What are their views to further strengthen compliance to protect the interests of both the employers and the workers? I will briefly walk you through it through the recommendation. Number one, ensure compliance with the ease in doing business law. Consider workers and management of enterprises as primary customers. I think this is an important part of the law that should be embedded in the system of the Department of Labor, in that they should consider both employees, the establishments, the management, and the employees as their customers, and they are duty bound to provide quality service. So there ought to be service standards. As I was saying earlier, there were some issues relative to quality of service afforded to the establishments. So I suggest that they could use the cervical model, that for them to be able to come up with their service standards, quality service standards. I think also it's important to rationalize the organizational structure of the Bureau of Working Conditions and the Occupational Safety and Health Center, because one of their complaints is that it takes time, a long time, before the regional director would be able to come up with a decision about those issues relative to compliance because of the hierarchical tendency of the structure. There's also a need to improve coordination mechanisms of all actors that are involved in the inspectorate. Actually, it's not just Department of Labor that is involved in the inspection. For export processing zone, like the PEZA, they do their own inspection. These are the export processing zones. The Bureau of Fire, the BFP, also does its own inspection. The DSWD is involved whenever the issue has got to do with child workers, and the local government units are also involved. It is important that the coordination must be smoothened, and then there should be no duplication in terms of functions, and that there ought to be more synergy. It is important that they delayerize and come up with a flat structure to promote swift decisions and actions. And by the way, it's important also that one of the issues there is the number of LLCOs is, to my mind, not really commensurate with the number of establishments that will have to be monitored, given the geographic landscape and seascape of the Philippines, and with 7,100 islands. The number of LCOs must be improved, but this must be anchored on a thorough study on how many exactly are the number of labor compliance officers are needed to do the work. Next one is that they need to do some job fine-tuning of job descriptions. One of the participants intimated to us, that some of the LLCOs that they have befriended told them that they have been doing a lot of things other than monitoring on labor compliance. I think it's important that they should have a sense of focus, and the job description must really be figured out properly. And there must be a thorough training needs analysis, because I realize that there are so many things to learn. You should know labor law, you should know engineering, you should know HR, you should know even maritime things, and there is not just one course in college that would equip you on that. So there must be substantiation in terms of knowledge and skills at the level of the department, and this must be anchored on, I guess, on a competency-based training curriculum. Okay, and then this also includes behavioral dimensions, because they will be dealing with people, and their aura in dealing with people like grievance handling, personal effectiveness skills, communication, conflict management, must also be part of the curriculum. And by the way, when they conduct training, it should be something conducive to adult learning. And they
Yeah,
should have labor inspectors confined only to their jobs. And since the job of labor inspectors is risky, I think it's important to have hazard pay. Essential logistics must be provided to them. And there must be an evaluation study because we are now in the regulatory approach. If regulatory approach is really effective, employer organizations should help police their own ranks, craft laws that further incentivize those companies that are compliant, review the current labor and OS laws, study the possibility of having separate code for micro and small enterprises, and require business owners to really participate on learning sessions relative to basic labor standards and OSH, and use other modalities of learning like what we have now, that you can do it in your own time and your own pace. Communication channels should be different communication channels should be used, and
Dong, do
very
you have?
important, I think it's important that yes, sir. They
Yeah,
stop the this work contractualization.
you
I
should.
guess that's it.
Okay.
I just like to end with what Stephen Covey was saying. Always treat your employees exactly as you want them to treat your best customers. I guess if the employers would have that consciousness, we will have a better employment relations at the firm level. Thank you. Salamat, gracias, merci. Thank you.
All right. Thank you, Dong, Professor Binghay, for a very comprehensive set of recommendations. You could unshare now.
I'm sorry. It
You
took
could
me too long.
that's okay. You can unshare now your
Okay.
screen. Okay, thank you, Dong. So, do you have any questions from the floor? Any questions? I don't see.
You're taking verbal questions?
David, yeah. Yep, David. Yes, David.
A question for Dr. Hebdon.
Okay.
Actually, I have two. What about legislated essential service designation by governments, such as the 2011 when the Ontario government declared Toronto public transit as an essential service? Would that fall under the category of what you were talking about, limiting collective bargaining? And I think if you took a close look at that legislation, in no way does public transit fit in as an essential service. It seems like an unjustified limitation of public sector collective bargaining.
Now? Okay, let me answer that one. Good question, David. I'm actually on that case. There is a constitutional challenge to the law that took away the right to strike for transit workers. And there is also an ILO case on it that clearly indicates that they're not essential workers. So it's sort of at the union is having some difficulty, I think, gathering all the evidence, because the employer side is arguing that, and their interventions actually by environmentalists, they're arguing that the health and safety of the public is put at risk during a transit strike in terms of air pollution and a whole bunch of other things. So, but it goes to the constitutional protection of the right to strike. And yes, it's definitely a case that will be heard. And, you know, based on the world and the rest of Canada, where transit work is not, including Montreal, where they have the right to strike, or a limited right to strike, transit workers do have the right to strike everywhere else. And it's an ILO declaration, and it's, I think it's a very winnable case for the unions if they want to pursue it, but it's been slow going. But you're right, it is a case and it fits into this category, and I could have included it, but I didn't.
Thank you. I have another question.
All right, another question? Okay.
You're aware that the Ford government in Ontario legislated Bill 124 about a year ago, limiting compensation for public sector workers by 1% over a 3-year period. It would seem to me that that should have the same fate as the cases you were talking about in Manitoba and Nova Scotia.
There is a part of my slide that I left out, unfortunately. Ontario should have been added into that. You're absolutely right. And I've just been engaged by the teachers to do my song and dance show on collective bargaining. That basically you can't have collective bargaining if wages are predetermined. They want me to do that as well. So yes, Ontario is it's the third province that I know of that has this formula of wage controls during, I know it's hard to say this, but normal times when they were passed. Not normal times now, given the COVID-19, but at the time that the law was introduced, there was no crisis. This wasn't 2008. There's no international financial crisis. There's no reason for the law, ostensibly. So they can bring in wage controls whenever they want. That's the issue. And I think Manitoba very clearly said, no, you can't. You can't take away collective bargaining rights in normal times without a financial crisis. So I think the Ontario case definitely is going to be affected by this Manitoba decision. If it isn't appealed, depending on the status of the case as we go on, who knows? Maybe this is going to be an outlier. But read the 120 pages or 130 pages actually. If you read that case, it's a pretty strong case. She's not wavering in this case. It's very powerful, I think, but I may be a bit biased.
Can't imagine why. Thank you.
Okay, any other questions? Well, I have a question for Robert. You mentioned the concept of meaningful collective bargaining. Could you elaborate on this concept a bit? How different is it from, well, I guess, ordinary collective bargaining?
Well, the court decisions in Canada, the Supreme Court has determined that in the Saskatchewan case that freedom of association covers collective bargaining and the right to strike. Sorry, that was the right to strike case. The 2007 BC Health included collective bargaining. So that raised the question immediately, industrial relations question, what is actually protected? What is collective bargaining? And what is, I guess more importantly from my slide, what is not collective bargaining? But one of the phrases used by the court, the Supreme Court of Canada, is there must be meaningful collective bargaining. And we only got this constitution in 1982. That's not that long ago for this court process. So we really don't know what meaningful collective bargaining is. I think we're working our way through that now. And I'm asserting that you can't have meaningful collective bargaining if wages are already settled by legislation. It's impossible. It's almost impossible. And that's what the court in Manitoba bought. They bought that idea. And so I think it's a step forward. I hope it's a step forward, and I hope it's, it's the floor that we can now build on in these decisions. Because a lot of the other decisions, the Meredith case, and I don't want to get into the legal scholarly work on this, a lot of the other decisions have to do with the 2008 meltdown, the worldwide financial crisis, which basically, the governments were allowed to take away collective bargaining for that period. But we don't have that now. I mean, when these laws were introduced, we don't have the financial crisis. So the question is, can they do this? And I think the judges in Manitoba is saying, no, they can't. You can't do that. You got to go do normal collective bargaining.
Well, what about the pandemic now?
Actually, what's happened in Manitoba is something that I started suggesting right at the beginning of this. They should negotiate it, whatever it is. So they actually just negotiated a deal with the Manitoba government workers of no layoffs for 4 days without pay, 5 days without pay, I think it is. 5 days without pay, no layoffs for a year. So it's kind of the Ray days, if you know the Ontario experience. They call them Phillipine Fridays, I think, in Manitoba. So they're going to be 5 days without pay, and the trade-off for that is no layoffs, which is fine. I'm happy with that. That's negotiated. That's what collective bargaining should be all about. It's not done by law, by legislation. I mean, I'm not happy about it, but that's, at least it was negotiated and it was a deal struck. So it seems like Manitoba already got the message from this. That's why I'm kind of optimistic that maybe they won't even appeal it. I'm an incorrigible optimist, though, I'm afraid.
Okay, thank you, Robert. Any other questions? Well, I do have a question for Virgil. Dawn, are you there? Virgil?
I'm here.
Dawn?
I'm here. Yeah.
You mentioned that this new set of rules on labor standards compliance. What prompted the new set of rules anyway? And I think the set of rules that it preceded was pretty much involving the parties in a self-check process, right? In that sense, preventive approach to accidents, for example. But now it seems that the present system is more really about inspection and about the complaints-based system. Could you?
It's back to, it's like a pendulum. It's back to more policing, whereas before it's more regulatory, it's more on their own. But now it's back to policing. And well, some employees are happy about it because they felt that at least the government is listening to them. As it was before, the inspection was very, very rare, and reportage of the thing is also not so timely and accurate.
Yeah, I think I remember some statistics before indicating that the compliance rates were somewhere in the neighborhood of around 50% only. And might that be one of the reasons why there has been a shift into this more dictatorial kind of enforcement that involves the inspectorate really being involved in the conduct of inspections at the workplace. But does
Probably
this not,
they have realized that the parties at the firm level could not be relied upon. The state has to come into the picture. But one thing is sure, the contractualization of workers still there, still rampant. There are diminution in terms of other violations, but with regards to security of tenure, the contractualization thing, that's still prevalent.
Okay, thank you very much, Don. Ed, are there other questions for our panelists?
I have a question for, oh, sorry.
No, go ahead.
No, go ahead.
I cannot
Yeah.
resist observing for Dr. Hebdon that the manipulation of the term essential, as in essential public services or essential services, is widespread. I saw it done many years ago in Hungary, long before their current authoritarian regime, in an effort to keep the railroad employees from striking, who had a pretty good stranglehold on the country's economy. And you certainly can watch Donald Trump declaring that ordinary food production workers are, quote, essential, and therefore the employer must reopen in the face of tremendous levels of disease in a COVID emergency, in order, in my personal opinion, to subject them to involuntary servitude, lest they lose their unemployment insurance. So that's a not so novel system of manipulation by employers that the Canadian developments fit into, sadly, a little bit neatly. So that's just my observation on that.
Just a quick comment. That's a good question. And one of the things that I'm asserting in the Toronto case, transit workers, is that governments ought not to have the authority, the power, to determine whether their own employees are essential or not. It ought to be determined by some kind of independent body, a labor board, a labor court, or something, because you know it's political. They just turn it into a political process. They're essential. So how can you have transit workers non-essential in every community in Canada except Toronto? It doesn't make any sense, and it's unfair, and it's unjust.
Let me add one other point, which is that there are US Supreme Court cases that I think go back to the 1940s that refused to apply the national emergency rules that were added to the National Labor Relations Act in Taft-Hartley to transit workers. So that might be a source of, notwithstanding the current retrograde situation in the United States, that might be an interesting source you would want to utilize.
Good point.
David, you were...
Yeah, just a quick question to Virgil, which might be
okay.
Off his topic, but it's something I was wondering about. In your research, have you noticed much activity or influence of transnational corporations in trying to affect, what you're talking about in terms of regulation, in terms of legislation, health and safety, whatever? Or do they just leave the matter to this?
Well, actually, some multinational corporations, they outsource some of their processes, and so they also do their own monitoring of these outsourced companies. And I just do not know if there's a good, very good compliance, if they report it properly. But I heard, in fact, I was supposed to be part of one company to monitor compliance of their cooperatives doing some farm work for that multinational banana and what do you call this, pineapple plantation down south in the Philippines. They do have, I know they have that. They have external bodies to do it for them. So I was saying I should have been part of it, except that I got sick during that time to be part of the team to monitor if the companies, the cooperatives that does the work for, that do the work for them are compliant as well.
Thank you.
Okay, I think maybe that's the last question and the last response. It's already time. Thank you very much, everyone, for
thank you also
for
thank you.
joining this session. Congratulations, everyone.
Thank you, Dr. Saleh
Thank you
and
very much.
Arlene. Okay,
And,
bye-bye.
yeah.
Thanks for giving up your Saturday morning.
That's right. Thank you, Robert, Dong, and
Bye-bye.
everyone. Thank you, guys. Shruti,
Bye-bye.
I turn over
Bye-bye
to you
from
now,
the
Shruti.
Philippines.
Bye, everybody.
Thank you, everyone, and enjoy the rest of the sessions today.
Bye.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.
So are we okay, Shruti, with